Hi everyone. If you're a shareholder, director, or manager of a company in Türkiye, this video is for you. We'll explain your personal legal responsibilities, especially for unpaid taxes, social security premiums, and other public debts under Turkish law. What is the general legal liability of board members in joint stock companies? Under the Turkish Commercial Code, board members of joint stock companies are personally liable for any damages caused to the company, shareholders, or creditors if they fail to fulfill their legal and statutory obligations. Even board members who have limited or no representation authority can be held jointly and severally liable with other members for the actions of company representatives, proxies, and assistants, tax debts and legal representative liability. When a company fails to pay its tax debts, and those debts cannot be collected from the company's assets, the legal representatives, which in joint stock companies are the board members, become personally liable with their own assets. If a board member fails to fulfill the company's tax obligations on time, they may be personally liable for these: the unpaid tax debt, late payment interest, tax penalties, and all other related public debts. This liability continues even if the company is dissolved or ceases operations. It's important to note that shareholders of joint stock companies are not personally liable for public debts. This responsibility lies with the board members. However, before pursuing board members, the authorities must first try to collect the debt from the company's assets. Only if the debt is not fully recoverable can they move on to the board members. What about limited liability companies? In limited liability companies, both managers and shareholders are personally liable for public debts in proportion to their ownership shares. Liability for social security premiums. When Social Security Institution (SSI) premiums and other related payments are not made on time, including these: SSI premiums, general health insurance premiums, unemployment insurance premiums, late payment penalties, administrative fines. In limited liability companies, both managers and shareholders are personally liable based on their shareholding ratios. In joint stock companies, board members are jointly and severally liable along with the company. This responsibility applies only to the period during which the person was in office. Even if they leave their position, they can still be held liable for unpaid public debts incurred during their term. What if the legal representative is a foreign national? A foreign representative of a foreign company operating in Türkiye can also be held personally liable for unpaid taxes or public debts in Türkiye. However, they have the right to recourse against the company for any amounts they personally pay. Does it matter if the manager is also a shareholder? No, it doesn't. Whether or not a manager owns shares in the company has no impact on their personal liability for public debts. Anyone who accepts the role of manager assumes this legal responsibility. When does personal liability begin and end? A director or manager's liability for public debts is limited to the time they held office. They are not liable for debts arising after their term ends, but they remain liable for any debts that occurred during their time in office, even after stepping down. As a company director or manager in Türkiye, you're not only responsible for internal company matters, you must also closely monitor the company's tax and social security obligations. Failing to do so can have serious financial and legal consequences that may affect your personal assets. Fulfilling your financial responsibilities on time is crucial, not just for legal compliance, but also to protect yourself from personal liability. If you found this video useful, don't forget to like, subscribe, and check out our channel for more insights on doing business in Türkiye. Thanks for watching.